Malawi Brief.
Atangotuluka a National Bank of Malawi mukafukufuku wa Amarylis Hotel amene akupitirirabe, nayo FDH inalowa mbwalo. FDH inayitanidwanso kumaloku kuti nayo izapereke mbali yawo pa nkhani imeneyi, nkhani ya malonda okhuza na Amarylis Hotel.
Lilongwe Mpeno, Vice Chair.
Thank you, Chair. Just wanted to get some clarification from the controlling officer. When you were explaining about the processes that you take to effect payment, you did indicate that accompanying the instruction to transfer, you had board resolutions. I just wanted to be clear, were these board resolutions by the board of the fund managers or the PSPFT?
Controlling officer, you can take that one. When we're done with that, we'll move to, there'll be a follow-up from the vice chair. Then we'll move to Mulanje Southeast. Over to you, controlling officer.
Through you, Chair, I'll take the question from Honorable Member from representing Lilongwe Mpeno, who is also the Vice Chairperson. The resolution was a resolution signed by the Board Chairperson of Public Service Pension Trust Fund. Thank you.
Thank you, Chair. It has transpired in the course of this inquiry that some of the board members did not know about this transaction or the sale agreement until a meeting that was convened by the central bank. I just wanted to check with you. Did you check that the board resolutions contained the names of all the board members of the PSPFT?
Controlling officer.
Through you, Honorable Chair, in terms of our verification, and this might be different for various organizations, but the board chairperson carries responsibility and is able to sign on behalf of an entire board. And within that understanding, if a document is signed only by the board chairperson, it is considered to be valid. So when we saw that it was signed by the board chairperson, we took it to be valid. Thank you.
Now, in the light of the information that I've just laid bare for you, that some members of the board were not aware of the transaction, do you regret effecting the instruction, or do you think you could have done better?
Controlling officer. Be at peace. You're still at your parliament. In the event that you feel that your colleague can supplement, you're free to do so. This is your parliament. Feel free and relax. In the event that you also want a break, you're free to raise a hand so that your parliament can remain accommodative as it has always been. Because we're not here like in a court. We just want to get information that is going to beef up to the inquiry that we're conducting, so that Malawians out there, those who trusted us with this responsibility, can have comfort. And those teachers, police officers, and public servants out there can have comfort that their future is secured. So feel free, relax, chill, then we get the required information. Over to you, controlling officer.
Thank you, Honorable Chair. My colleague, Head of Legal and Company Secretary, will take that particular question. Thank you.
Thank you very much, Mr. Chairman and Deputy Chair. I just wanted to put the matter into perspective, again, from a legal angle. So if you consider the nature of the relationship between a banker and his customer, you will notice that the banker is duty-bound to honor the instructions he receives from the customer. So if you consider the relationship we had with the managers, they presented an instruction. And as my colleague in risk has ably detailed out, we took some steps aimed at verifying the legitimacy of those instructions. We first saw the sale agreement, we saw the board resolution, and probably the fact that these were instructions coming from a regulated entity. Chair, there's a reason why we are emphasizing that these were regulated entities, because under financial crimes legislation, we are called upon to invoke simplified requirements when you're dealing with regulated entities, because they are also answerable to their regulator, the Reserve Bank of Malawi. So when you consider all these things that we put in place in order to verify the legitimacy of the instructions that we received, that's why we got comfort in executing the instruction. I must add that when we are honoring that duty, primarily bankers are not supposed to consider the underlying discussions that they may have, that their customer may have made with other third parties. But your duty is just to verify the instruction that you have received from your customer and see if it meets the requirements of the execution of your banking responsibilities. So we can still say that we found that the instructions were reasonable, especially considering that, as indicated by the controlling officer, board resolutions can take various forms. There are many forms in which you can reduce a decision of a particular committee. You can do it either through minutes, or you can have a board resolution signed by the board chair and the secretary, or the board members, or even you can delegate just to a company secretary, the board secretary, to just indicate that this is a certificate of a resolution from the board. So without wasting your time, Chair, we saw that the instructions were founded.
Take the last follow-up from Lilongwe Penu, so that we proceed to Mulanji's office. Lilongwe Penu.
Controlling officer, yes, we do agree that resolutions basically would be an extract of the proceedings of a meeting, in this case, a record of which is the minutes. And ordinarily the minutes will contain all those that attended the meeting, whose record is reflected in the minutes. So from this experience, don't you think that as bankers, you needed to be more careful? And again, you did indicate in your response that you trusted that this was coming from a regulated institution. And through this inquiry, it has also transpired that the regulated institution defied directives from the regulator. And in this case, you could not just rely on the fact that this communication was coming from a regulated institution, because we have proven that the regulated institution defied the regulator.
Thank you, Lilongwe Mpeno. Vice Chair, over to you, Controlling Officer. Take note that you've handled one question, then we'll proceed to handle that one, then we'll go to the next one. But you can address the one from the Vice Chair for now.
Thank you, Honorable Chair. Indeed, as you have highlighted, to indicate that there was an anomaly in the sense that not all members of the board were aware, or the trustees were aware of this transaction. However, if we look at the due diligence that we undertook as a financial organization, in itself was sufficient and within what we are supposed to do. When you look at it in hindsight, it can always go deeper and deeper and deeper. But as a regulated entity, there's a level of due diligence that we're supposed to undertake, and we undertook that level of due diligence. And as per our mandate to execute instructions that are provided by our client, as long as they provide the necessary information, we were also required to honor that instruction that we received on the basis that they did provide sufficient information for us to execute. The information is no different from other information that they submit to us in support of other transactions. And therefore, on our part, we followed the process and procedure and level of due diligence that was expected of us as a bank. Thank you.
Mulanje, Southeast, over to you.
Thanks so much, Honorable Chairperson. Just to state that I appreciate the level of detail that has been given by our colleagues from FDH Bank. Not to undermine them, I just wanted to understand why through your due diligence process you got the attachments that you have talked about, the board resolution, the sale agreement, and the sale resolutions. I thought that the idea of you getting those documents was to ensure that you would use them as part of your due diligence. And as part of due diligence is not to get the documents on face value, but to actually understand what the documents are talking about and to marry what the documents are talking about vis-a-vis the transactions that are being undertaken. And that's why this honorable committee is having an issue with yourselves. To say that here you are, as part of your due diligence, you have asked for a sale agreement that you want to run away from and say, no, it's not our duty to look at the sale agreement. But because, you know, these are regulated bodies and the instructions were duly signed, we have been dealing with them all the time, yet you are aware of why the Financial Crimes Act came into effect. It's basically to manage transactions that would normally say these are normal transactions. Because within the transactions that we say these are normal transactions is where people hide the financial crimes transactions. So here you are as a bank, a renowned bank for that matter, calling for these documents. And for the record, Chairperson, we just want to ensure that our colleagues from FDH do assert that the board resolution that we're talking about here, for the record, was signed by the board chairperson alone. And we would want to ensure that for the record as well, we get the date of the board resolution. The board resolution signed by the chairperson alone. We also want to ensure that we get the date of that particular board resolution so that we can marry it to the record that we have as to when the board sat and when these resolutions are expected. Secondly, Chairperson, I think we having an issue with you because having this sale agreement that says that there are particular milestones that are supposed to be met before further payments are made arising from this sale. And as far as we're concerned, the first payment was supposed to be 30% of the... are you aware of the milestones? Did you look at the milestones? Because if you were aware of the milestones that were supposed to be achieved to effect the next payment above the 30%, you would have realized that something was off. With between the 12th of January and the 26th of January, if through your due diligence you had looked at the milestones that were supposed to be achieved, what the sale agreement said that after the first 30% has been paid, the initial payment, what was supposed to be done to effect the next 40%, you would have realized that something was off. Lastly, Chairperson, I just wanted to find out from FDH, have you seen the press release from the financial regulator, the Reserve Bank of Malawi, revoking licenses of those that were sitting as trustees of the fund? If you have not, we would want the Secretariat to help furnish our stakeholder with that press release so that we can get an interpretation from them, because they have been relying on regulated bodies. And we want to find out from you why the regulator of regulated bodies, in this particular instance, is revoking licenses of trustees of the Public Pensions Trust Fund. Honorable Chairperson, submitted. Thank you.
Thank you so much, Mulanje Southeast, for such submissions and the question. Over to you, Controlling Officer, to attend to the question from Mulanje Southeast.
Through you, Chair, I will address the questions that have been raised by Honorable Member representing Mulanje Southeast. The first one to do with why we get the documents and why we did not go further. Chair, if I were to put it in perhaps a different kind of scenario where we have an individual who is a customer of the bank and they would wish to buy a house and they submit to us the transfer instructions to say that I would want to buy this house, you agree with me that as a bank, we will not go and question them, why this house, why not the one in Chinyonga, why are you agreeing with the seller to buy at this price? That would be in perhaps a more simplified environment. Now, coming to the case of our client, Public Service Pension Trust Fund, it is also not within our mandate to question the investments that they're making, because they have other advisors who are the fund managers who are responsible for making investments. They are the ones who will do a due diligence on the investment. So if they, the ones who are supposed to do a due diligence on the investment, then issue us with an instruction to proceed with the transaction, it is not within our mandate to question. The reason we would get this supporting document is to, one, verify that indeed they, the fund managers, are also acting within their mandate provided by the underlying client who engaged them to go into these respective transactions. And so in verifying, as I indicated in my earlier response, we verified in line with our mandate to the extent that we can verify. We cannot question details of a transaction to say why this price, why this seller. It is not within our mandate to do so.
Maybe before you proceed, you may recall that when you first appeared before this committee, you told this inquiry that you were once hired by NICO, that you could do a business valuation for the same transaction. And in 2023, you indicated to this committee that having done all the valuation, you were hovering around 25 billion to somewhere around 50 billion in terms of business valuation. And you went on to indicate to this committee when you appeared then that at that price, it was not viable business, according to the indications or the submission you made when you first appeared regarding you being hired on the same transaction. Now, 3 years down the line, in 2026, you have an opportunity to make a payment on the business that you had recommended that no, this is not viable at between 25 billion and 50 billion valuation that you had made in 2023. Did this not in itself, knowing that now you've gone past that 50, which you had recommended that, no, this is not viable. Now the same customer is coming to you and telling you, no, can you pay this, and it goes beyond 50, it's now at 90 billion. And you proceeded to pay because you're saying there was no need to question anything. Didn't this raise an alarm that, no, wait a minute, can we report this, can we check on this, or to have proper detailed due diligence on the documents which were presented to you? Because earlier on you had that privileged information that you had undertaken a valuation, business valuation of the same business, that 3 years down the line you were able to facilitate a payment of 90 billion. Did this raise a flag to the bank or not? Controlling officer.
Thank you, Chair. Indeed, we did conduct evaluation of the business in the year 2023. Perhaps I must also indicate to say that the capacity in which we carried out that business valuation was a different capacity from the custodial capacity that we used to settle the transaction. In our business valuation, we provided an indicative value of the business, and as is the case with every valuation, it is merely a guide on what we believe to be the fair price of the business. However, there is always a disclaimer that states that the final price is arrived at through negotiations between a willing buyer and a willing seller. Honorable Chair, our valuation was also done in the year 2023. This transaction was, if we look at the agreement, was signed in 2025. A lot of things may have changed from the time that we carried out the valuation. And at the time that we carried out the valuation in 2023, we were requested to carry out the valuation by the fund managers, who are the investment advisors, who were then responsible for the underlying due diligence We were merely providing a price. At the time of settlement, this transaction has again been settled using instructions from fund managers, whom we believe must have also carried a valuation at the time of transacting, and that price was guided by evaluation. So from our mandate, we could not have questioned someone else's valuation. These are technical expertise. People have different expertise. They have done their valuation. We do not know the information that was used to carry out that valuation. So at the face value, we cannot say that this value is wrong or right. The documents that we submitted to you, there was also a record of negotiations that took place. And as indicated, to say that even when we do valuations, we say that the final price will be determined by negotiations. And they showed us to say, well, we negotiated, and this is the value that we arrived at. We cannot dispute what the client and the seller agreed to transact at. Thank you, Chair.
So much. You may proceed to take. I see a hand from one of our colleagues. Please proceed.
Yeah, thank you, Chair. Just a supplementary on that, and to put it into record, in our valuation, we did not come with an opinion to say whether the business was viable or not. We merely provided a value so that whosoever is doing a due diligence will use that value to determine the negotiating price for the asset. So in valuation, we don't ascertain whether the business is viable or not. You are just merely providing a value as far as that business is concerned. Chair, I just wanted to put that into record. Thank you.
Thank you. There's a point of order from Mulanje's office. What has gone out of order? Mulanje's office.
Honorable Chairperson, I think we are being misled here. The last statement that has been made, that the business valuation that was done by FDH did not provide an opinion as to whether the business was viable or not, is misleading your Honorable Committee. Honorable Chairperson, thank you.
Controlling Officer, you were the one who made such a presentation. Can you retake that one?
Honorable Chair, in terms of the evaluation report that we submitted, we indicated that the value that was determined was below the value of the net asset value. And we indicated to say this is because the proceeds from the business itself gave us a value that was lower than the value of the net asset value. So this was mainly because of the value of the property itself. So there's a different value, which is the value of the business and the value of the property. So what we were saying is, as a business, the value was lower than buying the business. So our opinion was on the value and not necessarily on the viability of the business. We merely stated that the business itself generated a lower value than the value of the property. Thank you.
Thank you so much, Controlling Officer. I see Mulanje's office. Please proceed.
Maybe the stakeholder is forgetting, and that they be reminded that this honorable committee has the memory of an elephant. It doesn't forget at all, because the submissions that were made before this honorable committee were recorded. And the stakeholder actually told this honorable committee that as far as FDH was concerned, they did not see the business being valuable for the next 40 years. And that's on record. And for them today to retract that opinion that was provided on record is misguiding your Honorable Committee, Honorable Chairperson. Thank you, Honorable Chairperson.
I see Chitipa Central. Thank you so much, Mulanje Southeast, for refreshing the controlling officer and the team. I think they've taken note. Chitipa Central.
Let me yield.
Thank you so much, controlling officer. I see a hand from your colleague. Kindly take to the floor.
Yeah, thank you, Chair. I know the records were straight, and I also remember watching the proceedings. And I think the ones that did the due diligence in terms of payback period were Continental, because they came into this house to say, we found out.
Honorable Chair, if I recall, the second question was to do with the date on which the resolution was signed. The resolution was signed on the 25th of October, 2025. He further asked with regards to whether we have verified the milestones and whether they have been met. Honorable Chair, I would still like to take you back to our earlier response with regards to the difference in our role as custodian and the role of the fund manager that issued the instruction to us. The role of the fund manager, they are the advisors of the funds, of the client, and they are the ones that execute the investments. Verifying the milestones was not within our mandate as a custodian. This is something that would sit within the mandate of an advisor. So, in response to whether we verified whether each and every milestone was met, I would say that we did not, because it was not within our mandate to verify that. And then finally, we were asked if we have seen the press release by Reserve Bank. I myself have not yet seen it, but normally being the custodian of the fund, the Secretariat always writes to us when there are changes at the board level. As of now, we have not received anything. I have also not seen a newspaper today, so I may have missed it if the press release was in the papers. Thank you.
Thank you so much, controlling officer, but just take note that it has been released, and probably tomorrow it may be in the papers, but it's there circulating in the media, very clear and detailed. And this far, we haven't received any issues surrounding that, maybe from the Reserve Bank, indicating that it's fake. So as Public Accounts Committee, we would take it that it's an original and it bears the signature of the Reserve Bank governor. So we will proceed in that manner. Can I take to Chitipa Central? After Chitipa Central, we'll go to Nkatabe Central. Chitipa Central.
Thank you very much, Honorable Chairperson. I had the same views of Mulanje Southeast when he was talking of sale agreements and other requirements that maybe the bank needed that just to tick the box. But then looking at, hearing at our counsel here, he's a very careful person. He's a very serious person. He has cited all the regulations. He even took us to America talking about September 11. And then even our risk manager is a very careful person. They have talked about regulations that they can't give us information because the regulations protects them from doing that. Some of the information that your honorable committee would need to help with, to come with informed report. But then when it comes to 30% requirement, suddenly they are not that very careful. Careful people don't forget things like that. Honorable Chairperson, being a fair person, my thinking would be the fund paid 30%. And out of the carelessness of the bank, they paid more. I would say, why shouldn't Chitipa ask that the excess of the money comes from the pocket of FDH? If the fund gonna lose money, then they should lose 27%. The rest, 30%, which is like 27 billion, the rest should come from the pocket of FDH. So I wanted to give them a chance to say, why shouldn't we think like that, that the excess of the money was paid out of their own carelessness. The fund agreement allowed 30% payment for a reason, to protect their money. And the bank had a duty to protect that money. So why should we not think that or demand that excess of the 30% should come from the pocket of FDH? I submit, Chair.
Thank you so much, Chitipa Central. Controlling Officer.
Thank you, Honorable Chair. I've noted the comment from Honorable Member representing Chitipa Central. To say that it was out of our own carelessness, we believe is, well, we would choose to differ on that, in the sense that we take instructions. We are a bank. We rely on instructions that we have received. We do not pay just out of our own will to make a transaction. And we were executing an instruction that we received, which was supported by documentation that proved that the owner of the funds, or whoever has responsibility over the funds, has approved that transaction to take place. As a bank, we are mandated to honor an instruction that we have received. If I go back to the example that I was saying, a more simplified example, for an individual, if an individual wanted to make a payment and we refused to make that payment, that individual will go to the central bank and complain and say, the bank has eaten my money. So we were supposed to honor the transaction. If you look at it from our perspective, we know that the amount appears to be significant, but if we also understand the financial muscle of the client, whose value is over 1 trillion, that is not as huge a transaction relative to the fund size. So on our part in carrying out our due diligence, that transaction was within the normal course of activities that that client carries out. This is not the first investment that it has made. It has made several investments through the same fund managers, and we have executed the instructions with the same proof of transfer that we got for this particular transaction. So we acted in the best faith and within the mandate that we're supposed to do for the client. Thank you.
There's a follow-up question from Chitipa Central, but maybe before I get to Chitipa Central, I see a hand from FDH. Can you take to the floor?
Thank you, Chair. A supplementary on that one. The issue of a sale agreement, you can see also in the submission that we've given you, there is a letter from Public Service Pension Trust Fund instructing fund managers to transfer the 90 billion, apart from the sale agreement that stipulated 30%. Now, in the pension industry, trustees are mandated to do investments of any value. You can see that any other investments end with the trustees, the board of trustees, doesn't go beyond the board of trustees. So with also that instruction from the board of trustees of Public Service Pension Fund to say, pay, instructing the fund manager, it's in the submission, instructing the fund manager to pay 90.25 billion to Amarylis as a first payment. We also relied on that instruction because the trustees are mandated to do any level of investment because all the investments decisions ends with the body of the trustees. It doesn't go beyond them. So there was also, even though the sale agreement stipulated 30%, but there was also a letter that it's also included in the submission that highlighted that 90.25 be transferred. Chair, thank you. I just wanted to add that.
Thank you so much, FDH. Mulanje Southeast, what has gone out of order?
Honorable Chairperson, a lot has gone out of order. The stakeholder, is the stakeholder aware of complicity? When we say you are complicit in an act, do they know the weight of complicity? And for the stakeholder to come before the honorable committee, having proclaimed that they follow due diligence, as part of that due diligence, they got a documentation from the fund managers. And the documentation, as part of the documentation, there is a sale agreement, and that sale agreement stipulates when payments are supposed to be made. And he comes to this honorable committee and says, no, we disregarded the sale agreement, and we relied on an instruction that actually was at reverse, asking the bank or the fund manager to pay 90.2 billion against what was provided in the sale agreement. I mean, if the Financial Crimes Act actually stipulates that they have got a responsibility to ring bells, they are not a conduit. And the presentation that they're making to this honorable committee is that they're a conduit. If I say, please pay, they pay because I have told them. So we cannot go back to them to say you facilitated a financial crime. Is that what I'm getting from the stakeholder? Honorable Chairperson, thank you.
Controlling officer, you, like earlier on, indicated that in your due diligence, you engaged the board through assigned board resolutions, and there was a sale agreement, and the sale agreement, like you indicated, because you are the one who raised the issue about sale agreement, I only refreshed you that according to the sale agreement, there was a need to pay 30%. But in your case, you paid about 72% of what you're supposed to pay. 40% more. Basically, that's where Mulanje Southeast has issues. That you're picking issues to handle. On this one, you're trying to push it to the customer based on the instruction that you got that pay. But for you, you were in earlier on when you're doing your diligence, you had a sale agreement before you. That's where Mulanje Southeast has issues. Can you come out clear on that one, controlling officer?
Thank you, Honorable Chairperson. The sale agreement was for a total value of Well, after they negotiated according to the notes, they settled at 128.75 billion, which is the amount of the agreement. The amount that were requested to settle is below this amount. We take note of the milestones that were supposed to have been met. But as I indicated earlier, it was not within our mandate to actually verify each and every milestone. We would be going beyond what we're supposed to be doing as a bank. But we took comfort in the fact that the amount that we're settling is below the amount that they have agreed to sell. It's not one tambala above this amount. And in so doing, there could be many factors behind that could result in the 90 billion being paid. It could be that they did not pay when they met the first milestone. They paid later after attaining another milestone, because the instruction letter that we received was not a letter that said in respect of the first milestone. It was just a letter to say that they are settling the transaction. The advisors, in our opinion, would be knowledgeable of how much is supposed to be paid for the transaction, and hence advising us to settle. In respect of the letter that my colleague has also referred to, an instruction was also provided to say settle this amount. We could not question why they are saying to settle that amount. That amount is within the transaction price, not beyond. As to why, it is not within our mandate to question. Thank you, Chair.
Central.
Thank you, Honorable Chairperson. My follow-up is still on the 30% that they paid, that the excess should have come from their pocket, because I think it's a mistake. Maybe not a careless mistake, but a mistake. Or a deliberate one. It wasn't a mistake, if they don't make mistakes. I'm just looking at a scenario where I have $1 billion in their bank account, and in the internet banking, I'm allowed to transfer 50 million in a day. But then somehow I transfer 200 million and I lose that money. Will they claim that we got an instruction from you that you transfer 200 million and we proceeded? There's a reason why there's a limit to protect someone's money. And the reason of the 30% in the sales agreement was to protect the money. I would want to inform you, Chairperson, that I bank with FDH. When I do a lot of transfers, the bank will phone me. Your account has been transferring money. Are you the one? They are alerting me because they are afraid I can lose money. In this case, they say, no, we didn't alert anyone. We didn't report it to anyone, even though it was beyond the 30% in the sales agreement, because it was not within our mandate. Because the point here, the worry here is because they have not reported any suspicious conduct, because they see that in their due diligence, there was nothing suspicious. And in the due course, they pay more than what was stated in the contract agreement. And the argument is, we got instructions from the owner of the account. Now, if in that scenario I've given you, would they say that? Or I would be able to go to the bank to say, but then my limit is only 50 million. What happened to the other 150 million? And again, why do they alert me when I transfer 10 million kwacha? They will alert me because they are worried, suspicious that my account is transferring a lot of money. So, controlling officer, my question still stands. When you say, because you got instructions, if somehow your account has, not your account, your machines has somehow failed your bank and paid more than the allowable 50 million, which is allowed for me to pay, will you say, no, it's not our fault? That's my, I submit, Chairperson.
Controlling officer.
Honorable Chair, Perhaps I can say two things in response to the question that has been raised by Honorable Member representing Chitipa Central. The first one is to say that with respect to the transfer instructions, which you have received from ourselves, those transfer instructions do not specify that the payment that we're making are with respect to the first installment. So if it had specified so, then we would have verified the value of what that first installment was supposed to be. But it was a payment to be made. At which point they were in the milestones was not within our knowledge. The second thing I can say, this instruction was coming from the owner of the funds. With respect to the example that you have given, to say that when we notice a lot of transactions going through for a particular client, we will contact them because they are the owner of that account to verify. In our case, we had the owner of the account giving the instruction to pay. So we cannot question the owner to say, why should we pay your money to buy this when the business of that owner is actually to be investing? So we acted within our mandate, yes.